Welcome to Tampa Home Talk with your host, native Tampa real estate girl, Katrina Madewell, a full-time, passionate, out-of-the-box thinker, love for home ownership kind of realtor with over 21 years of combined mortgage and real estate experience. Tune in every week at this time for expert advice on everything you need to know about home ownership, finance, maintaining great credit, building wealth, and making your everyday life better, and how you can be financially successful today and tomorrow. Remember, love where you live or let Katrina fix it. Now, here's your host of Tampa Home Talk, Katrina Madewell.
Good afternoon. Thank you so much for joining us this afternoon for Tampa Home Talk. I'm your host, Katrina Madewell, and we have a really great show lined up for you today. It's in and around one of the things that we get pretty regularly when we're out in the field of real estate. Now, the mission of our show here at Tampa Home Talk is to help you keep and maintain great credit, live within your means, and build wealth. And then in and around that, we always bring a bunch of fantastic guests just to make your everyday life better and also answer different real estate questions that we see when we're out in the field. So I'm super excited to announce our guest for the show today, Jim Holloway. Jim, thank you very much for joining us.
Thanks for having me.
Can you tell the person listening a little bit about your background? Like you're an attorney. And you are in-house with Hillsborough Title, which is one of our show partners.
I am with the Florida Agency Network. In fact, it is the largest title agency in the state. They have 27 offices around the state. I'm the general counsel for the Tampa Bay division, and I've been with them for 3 years. Prior to that, I was a partner in a South Tampa title agency, and before that, I sued pharmaceutical companies.
So for a long time, you've pretty much been in and out of the title sphere. I mean, you know that.
Before I went to law school, I was a builder for 7 years. My family was in the construction business in Gainesville. So I came to it fairly naturally, grew up with it. When I started practice in Gainesville, because I knew realtors in town and builders in town, they put me right into the real estate department. Came to Tampa in 1998 to do some litigation work. I find that having a litigation background is very helpful in real estate because people often want to throw down.
It makes sense to me.
Dance the dance.
As I was saying before the show started, my background's in mortgage, so that is ever so valuable a lot of times in the real estate world. So our show today that we have lined up, we wanted to discuss the topic of what we call in the real estate industry is Post and Pre Occupancy. And so what that means is post occupancy by a seller, meaning that the file was supposed to close at the end of the month, close escrow, meaning the seller should be out, the buyer should be in. But for whatever reason, the seller wants to stay. That's what we consider post-occupancy. And then pre-occupancy would mean, maybe the buyer's lender stuff isn't quite ready or whatever that situation is that we see, and they want to actually take occupancy and move in a little bit before they close escrow and make it their own. So we're going to talk about each one of those scenarios and, the what-ifs and what goes into those. And Jim's going to tell you about the legal aspect of that on why most attorneys, would you say, would frown upon post or pre-occupancy for the most part, right?
I certainly frown on it.
And I would as real estate background. So let's talk about the one we probably see more often than not. So pre-occupancy by buyer. We'll start there.
Well, actually, I see about half and half. But
do you?
Yeah, I do. Pre-occupancy, like you said, the buyer's loan documents didn't get done, whatever happened. Usually you're talking a relatively short period of time, in most instances, a week, 2 weeks. That the buyer, they've sold their house, they need to move in, they've moved to town, whatever the case may be, the seller's already left their house. So somebody, they need to move in.
We're thinking no harm, no foul. It's empty. We could just move in. We only need a couple days, right?
Sure.
That's usually what we hear.
Sure. That's exactly what we hear. And the next news, they just, handshake deal. Okay, go ahead. Yeah, you're a good guy. We've been working with each other for a month now. We've been under contract, and you're going to close. And
all right, do you see that more like in for sale by owner type stuff, or do you see that when there's real estate agents involved?
I see it both. Most real estate professionals, like you and me, we try to discourage the practice. Frankly, it's not something that we encourage because what can happen is
it's the worst case scenario we're always thinking about.
Well, it's a slippery slope, as they say in law school, and next news their loan didn't get approved, and they're living in your house and they didn't buy it. And that's a problem.
So let's use that scenario. I mean, you talked about a handshake deal. So you have one end of the spectrum to another. And then I printed the riders also that would go with the contract, which is all we're able to use as agents, whatever's, pre-printed by Florida Association of Realtors and the Florida Bar. But so using that particular example from someone that does a handshake deal, nothing signed, no lease, nothing. They just say, hey, I just need a couple days or 1 day or a week or whatever. I'll give you $500 or $1,000 or whatever it is to stay. Yeah. And then talk about the other end of the spectrum where they do say the addendums that I gave you, the preoccupancy by buyer, and then, something happens.
Well, when I do these, the riders are great, but really what the riders do is they call for a written lease between the parties.
And would you say they prepared it like that to clearly define the relationship between the buyer and the seller and tenant?
Well, yes, I think they prepared it like that to create a tenancy as opposed to a squatter, if you will.
Will you just clarify on that? When you say create a tenancy, can you just break that down?
There's essentially a landlord-tenant relationship between the parties.
Gotcha.
The person living there is a tenant. The person who owns the house is the landlord.
Okay.
And that's really what you want to establish in my mind. The terms of the lease, it can be, as you said, at one end of the spectrum, you got the handshake. At the other end, you've got, the full written Florida residential lease that, is a pretty sophisticated document. We try to get somewhere in the middle.
Gotcha. So let's say we'll use that scenario, and probably one that we would see more common than not. Let's say maybe the buyer loses their job or their loan doesn't go through for whatever reason. They thought it was going to go. The lender changed their guidelines, whatever that reason is that the loan is not going through. And now this couple days or a week turns into a month that might turn into who knows how long.
Well, I have an anecdote. A friend of mine was a builder in Gainesville, Florida. Built a house for some folks. His son worked for him. The son was the, hands-on guy in the field building the house. He'd been working with the folks for 4.5 months. Great people, never a problem. They showed up with a moving truck at 6:30 in the morning. He drove by, said, hey, how y'all ready to move in? They said, yeah, can we go ahead and get the keys? We're going to close at 11:15, but, the movers are here. We'd like to get started. Sure. Young guy right out of college gives them the keys.
So most people are thinking, oh, they're great people.
Absolutely.
They've been the nicest. We've spent almost a half a year together.
They've signed a form that says there are no defects with the house. Go ahead, move in. And Dad calls him at about 11:30, says, hey, where are the Joneses? They haven't shown up for closing. And, of course, this was in the days prior to cell phones, so he beeped him, and he had to, go up to the old payphone and calls his dad and says, what's the matter? They haven't shown up. Well, I'm sure they're just moving stuff in. They'll show up. Long story short, they never showed up. He had lost his job the day before closing.
So how did they figure this out? Like, did they go buy the property? Like, when did they eventually figure out that they weren't coming?
The friend went by the property, and the door was locked. The folks were in the house, and they weren't answering the door. And what are you doing? Well, we're living in your house. And we had to file, a lawsuit was filed to get them out. And it took us about 6 months to get them out of the house. Everything in the world became wrong with that house. There were problems after problems that had never been mentioned during construction, but they needed a place to live, and they found one.
So they kind of took advantage of the fact that the young kid said, yeah, sure, no harm, no foul. Here's the keys. I'll see you at 11.
Yeah. Yeah, my client's son said, we had never had a cross word in 4.5 months. And they signed a sheet saying there were no defects in the house.
So what does that look like from the court standpoint? Like, how messy is that? What has to happen from a legal perspective?
Well, it's extremely messy because they had given him the keys without any agreement between the parties establishing the landlord-tenant relationship. You have to file a lawsuit called an unlawful detainer. It's an unlawful detainer because they were given the right to go into the house. They just didn't leave like they were supposed to. Same scenario. Say
So
you,
it's permissible. I mean,
Yeah,
there's,
yeah.
we run into this where someone says, oh, we're going to let you, stay here for a couple of days. You can sleep on the couch. And then that can turn into like a civil matter,
same
right?
thing. It's a civil lawsuit. Unlawful detainer. You want to use my condo at the beach for the weekend here, and they just don't leave. You got to file a lawsuit. Now, on the upside, you do get the benefit of, I believe it's Chapter 5511, the truncated time for them to answer. You have to file the lawsuit. A summons is issued, just like an eviction. You have to give it to a process server or sheriff. They knock on their door. You're being sued for an unlawful detainer. They have 5 days to file an answer. If they don't file an answer within 5 days, you can get a default judgment against them. Go to the sheriff, go back to the court, get a writ of possession, give the writ of possession to the sheriff, and the sheriff will go with you or your employee to move them out.
And so that timeline, like if they don't respond within 5 days, what's the timeline for that? Still 6 months to get out?
No. It's about less than that. It's like an eviction, similar to an eviction. It's not an eviction because you don't have a lease with them. You don't have a landlord-tenant relationship. But it's similar in time, and it takes about a month by the time you get it served. Service can often take a week or two. They can avoid that guy knocking at the door.
So what happens if they hire an attorney and they respond to that? How does that change the timeline?
Well, that's what the folks did in Gainesville, and that's what turned it into a 6-month battle.
And what claim are they making at that point?
They're making a claim that they're not closing because it's not right. Something the seller has done.
Something's wrong with the house.
Yeah, something's wrong with the house. A failure to disclose in a common real estate context. That type of claim.
Which is pretty amazing when you think about it. And so when we come back in just a couple minutes, we're going to take a break, but we're going to talk about, what happens if, for example, somebody trips and falls, or there's a fire and this buyer is preoccupying the property. You're listening to Tampa Home Talk. I'm your host, Katrina Madewell. Jim Holloway in studio here with us. We'll be back in just a minute.
You're buying a house. Congratulations. So while you're worrying about the paperwork, leave the moving part to us. We're Woody & Sons Moving Company, a Florida licensed and insured mover, and we offer same-day written estimates. Plus, no sneaky mileage, stairs, or additional stop fees. All we ask is that you check out our great ratings on Google and Angie's List, then go to woodyandsons.com to learn more. Whether you need a full-service pack and move or some extra hands, at Woody & Sons Moving Company, we move you.
Hi, this is Aaron Davis, owner of Hillsborough Title. Hillsborough Title is a local, family-owned title agency here in Tampa Bay. Our service, strength, and knowledge make us different. We've served Tampa Bay area for over 30 years. From Polk County to the Gulf, Pasco to Manatee, Tampa Bay, we've got you covered. Call us at 813-712-8888 or visit us on the web at thebesttitle.com. That's thebesttitle.com.
You've heard this before. Interest rates are at all-time record lows. But if your interest rate is 4% or above, you owe it to yourself to call Silverton Mortgage Specialist. Silverton is a direct lender, and the best part about this is that the entire loan process is handled in-house. From application to close, we do it all in the same building, which means that our loans close fast and our clients know what's going on every step of the way. Our contact info is located on TampaHometalk.com under Radio Show. What makes Silverton different? Products. We offer VA, FHA, USDA, and conventional loans pricing. Best rates with the lowest closing cost. Process everything in-house. It's handled right here and not outsourced to anyone that no one can reach. This way we can avoid surprises. Our people are simply the best, and we know you'll agree. What will closing Silverton Mortgage Specialist mean to you? A smooth process, real home loan value, and personal attention from real professionals. Silverton Mortgage Specialists are here to serve you. Visit TampaHometalk.com under Radio Show for all of our contact details. NMLS 109600 is an equal housing lender and Florida and Georgia residential mortgage licensee.
Welcome back. You're listening to Tampa Home Talk. So to continue on with the first segment of today's show, we're talking about Post and Pre Occupancy by a buyer and a seller. So what happens if it doesn't close on time and someone's in the property and they have permission, they don't have permission to be there? We talked about quite a bit in segment 1. But when we got ready to take a break, I was saying we were discussing if a buyer moves in ahead, they haven't closed escrow for whatever reason, not actually their house, no lease. And then, so in this particular scenario, let's say, they put a pizza in or whatever, and they start a fire at this point. So maybe they had homeowner's insurance already for the loan, and it was effective for that day, but they're not actually the owner.
Well, generally, it's really treated like a rental property. Okay, the seller is going to keep their insurance in place. Probably need to notify their carrier that they now have a tenant in the property to make sure it's good with their insurance contract.
Which we know most of the time in this scenario that probably would not happen.
That they would not contact their carrier.
That's the last thing they're thinking about.
Well, they're going to talk to me. If they're closing at Hillsborough Title, they're going to talk to me, and I'm going to bring it to their attention because we don't want any defense to the coverage. So just like a landlord, you're going to keep your liability insurance and your homeowner's insurance in place until the buyer takes ownership. Now, we strongly recommend to the buyer, if he's pre-occupancy or the seller in a post-occupancy context, that they get renter's insurance as well. That's going to cover them. And you've really got to have some written instrument because, number one, you want to create that tenancy. And number two, you want to define the responsibilities of the parties. Who's going to be responsible if, the buyer who's occupying the home early does something and breaks the stove?
Well, I was thinking, too, like, what about even maybe, they have their good old buddies come move them in. And what happens if they slip and fall or they break something, right?
You're still going to have your liability insurance in place, your homeowner's insurance, which provides liability, checking with the carrier to make sure that your insurance contract remains in place, even though you've let these people move in and establish a tenancy. You want to contact your agent, make sure your contract's in place. They may need to do an addendum or amend your insurance. So that provides coverage in the event their buddy falls and breaks their leg. Supposing there's the proverbial loose stair.
Right.
Okay. And he falls down the stairway, that coverage will be in place. Similarly, in the context of the seller staying in the house, the buyer's going to have their insurance in place. The seller needs to get renter's insurance.
We see just so many crazy things. Like I could see the insurance companies totally pointing at each other going, not my fault.
That's why you don't really want both policies in place at once.
So you're saying they kind of would counteract each other?
They'll say, "Oh no, it's your policy. No, you want to stay away from that. You don't want the insurance companies fighting over who provides the coverage."
It makes sense to me. So, is it safe to say in that scenario, or even like for sellers, I would say we see a lot of times if it's maybe like an older seller and they needed more time to vacate, that kind of stuff.
Sure.
And it didn't happen. I mean, I don't even know how that would look, to the courts if it's an older person and they're like, they just decide they don't want to leave.
Well, you go back to the unlawful detainer. Or if you have an agreement in place, it's an eviction. Courts, it's much easier for a court to deal with an eviction than an unlawful detainer. I heard an attorney on the radio one day not too long ago give advice that, I don't think he's a real estate attorney. I think he does other types of work. But he said, well, you just post the notice, the 5-day notice. You then call the sheriff. If they don't move out in 5 days, you call the sheriff and the sheriff goes and gets them. It's not that easy. It generally takes, I do a number of evictions for clients. It generally takes me about a month. Could be less if, the world is all perfect and the judge signs the default on the 6th day after they don't answer. Starting out, the clerk has to issue a summons and they have to be served. If the clerk issues a summons the first day after you file your lawsuit, if the people accept service on the first day, then their 5-day starts. You get an immediate default judgment, and get you rid of possession immediately and get it to the sheriff's office immediately, maybe a couple of weeks.
Best case scenario,
Yeah,
2 weeks.
but generally it takes about a month. Judges, they don't sign as quickly as the owner would like.
Right.
The sheriff doesn't get the process server doesn't get it served. They may avoid service of process. They hear the guy knocking at the door and they just don't answer.
Which, if they don't want to move out, they probably are going to avoid.
We have actually paid process servers additional funds to basically camp out in front of their house. and when they walk out to get in their car to go to work that morning,
then they're going to
perfect service of process.
So it was interesting. I had this come up actually right at the end of the new year. One of the gals on my team, she had worked with the buyer, and the seller was just taking his time to get out. And this agent was just on the other side, was trying to pull some funny stuff. And so when I went to do the final walkthrough with the buyer, and we were already like a half hour late getting there, and then we're supposed to go straight to close escrow. We get there, and the seller still has all this stuff. I mean, there's a car on the property that doesn't even have a tag. We have no idea if it runs. There's 2 sheds full of stuff in the back. There's stuff still in the front, and there's stuff still inside the house. There's a moving truck in the front. And they're like, oh, yeah, we're taking our time to get out, blah, 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 all this stuff. So they leave and follow us to the title company to close. And so I walk in and I said, the seller's still vacating the property. So I said, the buyer's here, they'll do their part and sign, but this can't fund until they're completely out.
That was a good call.
And they sign on a walkthrough. And, and I was trying to explain this to the buyer, and of course I'm not an attorney, but I'm thinking all these what if, worst case scenarios. And, and then the buyer even brought up things that I didn't even think about. And I told them, I said, what happens if that car doesn't run and they decide they don't want to move it? Are you going to tow it off at your expense? And then what? Are they going to fault you saying that you damaged their car or move it, or where is that going to go? And they're like, yeah, well, what if it even has drugs in it? I said, that's another whole thing I hadn't even thought about. All of those scenarios are possible.
That's the parade of horribles.
So what happened was we ended up having this big blowout, and I told the escrow agent, I said, we really probably should have came at separate times to sign. That probably would have been a good idea in this scenario. And I said, so here's what we're going to do. I said, the buyer's going to fulfill their part of the contract and sign, and if the seller's completely vacated and done, when we go back to the property during the walkthrough, we'll be good to go, and we can close and fund today like we were expecting to. I said, but if everything's not gone, including the junk car, on the property and all this other stuff, we're not going to be able to let this file fund.
Yeah, no, you don't want to fund because there is a parade of horribles.
And so when you think about that scenario, though, it's kind of like, all right, so then, we kind of scared them a little bit because they wanted their money. So then what happened was when we came back after the buyer was done signing, and, they're like under pressure now because they want their check, they want their money. Their part takes 5 minutes. The buyer's like 45 minutes. So there was all these people there. And then, the one homeowner, the lady, the new buyer, she went to the Home Depot or Lowe's to get new locks, to change the locks, and then he was going back with me to do the final walkthrough to call the title company and let them know. When we got there was probably about 8 different people just pulling as much stuff out of the shed and out of the property they could as fast as they could. The car was gone, and then so the new homeowner, the buyer at this point that's waiting to fund and officially be theirs, he says, how do you know the seller? And they said, oh, we don't. We were going to the grocery store, and they just said they have to get all this stuff out of the property within an hour. And he says, so you don't know the seller? And they said, no, we're just taking this stuff out for scrap metal, and we're going to pay our rent with this stuff. And I'm sitting there in my head thinking, oh my gosh, my call was so spot on, because imagine one of these people that don't even have the money to pay their rent. If they were to slip and fall and break something, who the heck is liable at that point?
Absolutely. It's, it belongs to the seller until it funds. The minute it funds, it belongs to the buyer. So you made a very good call in not funding. And of course, the seller, pursuant to the contract, is obligated to have it clear, free of debris, and broom swept condition.
Right.
And deliver occupancy on the day of closing. Possession and occupancy the day of closing. So, the basis for your refusing to fund would be the seller's breach of that provision of the contract.
And there's so many things, like when they move stuff out, what happens if they do damage? I mean, I know that you mentioned that when you allow and, everything's clearly written out, the paperwork's prepared by an attorney like yourself, and it's very clearly defined. Like, you have different things like the utilities you have to address. You have damages. What happens if they damage stuff on the way out? What other kind of things are in there that someone should be thinking about?
Rent.
Right. Prorated amount.
Prorated amounts. I provide... big thing is I want a substantial amount of money in escrow.
So let's use just, the average sales price in the Bay Area is right about $200. So let's use that scenario. It's about $200,000, and they've agreed to let the seller have 2 days or a week, or let's say a week. In this case, it's 7 days. $200,000 property.
It's really the parties' decisions, but what I tell them is you want to make it enough to hurt.
So if you were the person that was selling or buying the property, and you're letting the seller stay, or vice versa,
I'd probably want $5,000-$10,000 if it's me, because I want enough for it to hurt. I want some pain, and I also want enough money there to reimburse me if I have to file a lawsuit to get you out. That's the other thing you want in your occupancy agreement is an attorney's fee provision, so that if one party or the other breaches, if they don't leave on time, then you want an attorney's fee provision. If you have to hire a lawyer to go kick them out, it's going to cost you some money.
And I imagine the standard FAR bar contract, for example, even though it's in the contract, the mediation, arbitration, and then prevailing party gets fees and costs, meaning
right.
Whoever wins the lawsuit. I would imagine that probably would not carry over in that instance, would it, or does it?
Not really.
Gray area could go either way?
Not really, yeah. I would, I'm going to do, because you're establishing a separate contract. A lease is just another contract. And I want it in my lease contract that they're going to pay attorney's fees if I have to file an action to get them out.
Which makes sense. And so have you run across any other horror stories or heard anything about like damages the way out or anything like that?
I have. I've never had people fight too much about it because that's the other reason you want that escrow there. And we're not going to give that seller their escrow money back until that buyer tells me I can release it, as you know. And if that seller wants their $10,000 back, they're going to pay to fix the door jamb that they tore off with the couch when they were coming out.
So they're getting everything but that predefined amount that they're going to leave behind.
Yes.
And then...
Yeah, they're going to get everything but the amount that they agree to hold in escrow.
Is there a provision in there that essentially says, okay, you did damage, you scraped the walls, I've got to have that plastered and painted in a new door because you ruined that on the way out?
Yeah.
Is there a provision that it just takes the cost out of there, or all that stuff has to be...
It says that the occupant is going to be responsible to maintain the property in the condition it was in when they took occupancy. So if it's a seller, it has to be the condition it was in when they closed. If it's a buyer preoccupying, it has to be in the same condition as the day they occupied, except for normal wear and tear.
And I'm curious if this probably comes up a lot. Oh, this was there. No, it wasn't. Talking about damage. And that's a funky thing to prove, I'm sure.
It is. But again, we've got a chunk of money that's not going to be released until they can agree.
So if someone did say a video, when before or in between the parties, for whatever reason or another, sellers out, buyers in early, whatever, they do a video of the property.
Just like a landlord. I tell landlords, take pictures of your property, and tenants too. I tell tenants, take pictures of the property the day you occupy. That way, if the landlord comes back to you and says, you damaged this, this, and this, you've got pictures to show, no, I didn't. It was in that condition when I moved in.
Now, what I usually suggest, and we don't really do any property management or anything, but what I've suggested is they actually take a video and then upload that to YouTube so it's time-stamped.
Yes.
Would stuff like that hold up in court?
It's a great idea. Yeah, sure it would.
Okay.
Absolutely. I love the idea of a timestamp. A lot of photos will timestamp. I don't know how to make it work,
right?
But my kids do.
That's right. Just ask any man under 25. It's exactly how to do it.
Exactly.
So the one thing we didn't talk about, and I've sort of encountered this, but not really, is what happens if there's squatters in there, or a homeless person, or somebody that is, you didn't give them permission to be in there, but they're there.
I run into that very often, especially with our institutional clients who buy significant numbers of homes at foreclosure sale.
So I just want to clarify what you mean by that. You're talking about like someone's buying a foreclosure sale or an auction, and then you have either like a company or a hedge fund or investor or somebody that has never seen the property. They're buying it based on numbers.
Yeah, they may have seen it, but it may have been, a couple of weeks since their representative looked at it, and somebody's moved in the interim. One would think that a sheriff would just come and throw them out, but they won't. There's a separate cause of action called an ejectment. These are for people who took possession of the property without the permission of the owner. And again, similar to an eviction, but a separate cause of action that says, Judge, these people are in my property. I don't know who the heck they are, but I own the property, and you got to get them out of here. But it can be costly.
It never ceases to amaze me. I know that I've never had that issue where someone's moved in between the time that we originally saw the property and did the final walkthrough. But I have had cases where I was out showing property, and we're walking through this REO property, and there's a homeless guy that just ran out the back. There's like canned goods in there and a rolled up towel, and he's made a little pallet that he's sleeping on.
Well, especially, foreclosures aren't taking quite as long today. But, when foreclosure a couple years ago, it was not uncommon to have a 2-3 year foreclosure. House would be vacant for a significant number of time. People move in. Then there's a whole adverse possession deal, but that's another conversation.
Well, what is adverse possession? Because you've mentioned a couple things. You mentioned unlawful detainer, which is where you let them move in.
The ejectment.
Ejectment, meaning you don't know they're in there, but they're in there.
Right. And it may be it may be the owner who got foreclosed on, who just doesn't want to leave. It's been a pretty good gig. I've been here for 2 years.
And so now the bank's kicking them out.
The bank owns the property. We got to get them out of there. They're there without my permission. I have to eject them.
How long does that take them usually to go through that if it's an ejectment compared to?
It's a similar amount of time.
Is it?
Yeah, it's similar time and money. They're all three, ejectment, unlawful detainer, and eviction are all similar causes of action. But with an eviction, you have a lease. And again, judges and courts are much more common with eviction than they are, although they've certainly in these times become more acquainted with ejectment and unlawful detainer.
They've gotten brushed up on the Florida statute pretty well, I would imagine.
They have.
So you're listening to Tampa Home Talk. We're going to take a real quick break here. We'll be back in a couple minutes to continue our conversation regarding post and pre-occupancy. Back in a minute.
You're buying a house. Congratulations. So while you're worrying about the paperwork, leave the moving part to us. We're Woody & Sons Moving Company, a Florida licensed and insured mover, and we offer same-day written estimates. Plus, no sneaky mileage, stairs, or additional stop fees. All we ask is that you check out our great ratings on Google and Angie's List, then go to woodyandsons.com to learn more. Whether you need a full-service pack and move or some extra hands, at Woody & Sons Moving Company, we move you.
Hi, this is Aaron Davis, owner of Hillsborough Title. Hillsborough Title is a local, family-owned title agency here in Tampa Bay. Our service, strength, and knowledge make us different. We've served Tampa Bay area for over 30 years. From Polk County to the Gulf, Pasco to Manatee, Tampa Bay, we've got you covered. Call us at 813-712-8888 or visit us on the web at thebesttitle.com. That's thebesttitle.com.
You've heard this before. Interest rates are at all-time record lows. But if your interest rate is 4% or above, you owe it to yourself to call Silverton Mortgage Specialist. Silverton is a direct lender, and the best part about this is that the entire loan process is handled in-house. From application to close, we do it all in the same building, which means that our loans close fast and our clients know what's going on every step of the way. Our contact info is located on tampahometalk.com under radio show. What makes Silverton different? Products. We offer VA, FHA, USDA, and conventional loans pricing. Best rates with the lowest closing cost. Process everything in-house. It's handled right here and not outsourced to anyone that no one can reach. This way we can avoid surprises. Our people are simply the best, and we know you'll agree. What will closing Silverton Mortgage Specialist mean to you? A smooth process, real home loan value, and personal attention from real professionals. Silverton Mortgage Specialists are here to serve you. Visit TampaHometalk.com under Radio Show for all of our contact details. NMLS 109600 is an equal housing lender and Florida and Georgia residential mortgage licensee.
Welcome back. You're listening to Tampa Home Talk, and I'm your host, Katrina Madewell. We were talking today in studio about post and pre-occupancy, meaning post-occupancy by the seller. They're staying a little bit after the time they're supposed to, and pre-occupancy by the buyer, meaning they are actually wanting to move in before the home is theirs. And so during the break, I thought that would be a great story to share because we were talking about a scenario that you've ran into in your travels of law over the last several years. But you had a scenario where, you know, the seller did their part, the buyer did their part, and they're going to do their final walkthrough.
Well,
and there's still stuff in there.
The buyer gets to the house with their realtor the day before closing to do a final walkthrough. Which, by the way, the seller is required to leave their utilities on so they can do that walkthrough. Don't turn them off until the day of closing. The house is still full of furniture. The buyer's agent called the listing agent and said, "I thought your folks moved out. What are we doing?" And the listing agent said, "Oh no, that's the tenant's furniture." Well, what do you mean the tenant? And the listing agent thought that the tenancy would terminate upon the sale of the house, which of course it does not. The buyer takes subject to the terms of the lease, and this lease had another 6 months to go. So needless to say, the deal fell apart. And
so let's break that down for a minute. So someone's, they leased a property from January through December. This property is closing escrow, let's say in June. So it's midway through that lease. The buyer was never made aware that, hey, this is actually a tenant in the property. It's not the homeowner that's there. And they're expecting to just buy it and move in. They got moving trucks lined up, whatever the scenario is. And they go, oh, by the way, nah, it's a tenant. So you're saying that the listing agent actually thought that lease was going to terminate upon the sale.
Yes, they had not talked to the tenant. She just thought that it would terminate upon the sale of the property. He doesn't know anymore. How can he be the landlord anymore?
So was the tenant planning to stay?
Yes, the tenant was. The deal fell apart, and they argued for a while over the damages because it's clearly, as you know, it was a FAR contract. It has a provision, I believe it's even on the first page, where you have to disclose if the property's leased. They didn't check the provision for the lease.
There's a place on the seller's disclosure too.
Yeah.
So the seller's disclosure should be completed, and it's my opinion that whether the seller has ever occupied the property or not, I like to get it signed, even if they put a line all the way through that seller's disclosure and initial it saying, hey, I don't know anything, but they're going to acknowledge it.
I agree.
But there is a place on that seller's disclosure that states if it's tenant occupied or not, and when that lease is up.
Right. It's right there on the first page of the contract, or second page maybe. But, you can't miss it.
So there's a couple places.
Yeah, they needed to disclose that, and they just, failed to disclose it. And like I said, it was clearly a breach by the seller, and they argued over how much the seller was going to have to pay because this buyer couldn't move in.
It's really, at that point, that would be a non-disclosure issue, right?
Absolutely. And a breach of the contract for failing to disclose the existing tenant.
And so, the regular contract would assume at that point that they're going to be completely vacated because they've never disclosed there was a tenant.
Contract says that they are going to deliver possession and occupancy the day of closing. But again, she thought it would just terminate the lease and that the tenant would move out and they would move in. And she was going to call the tenant that day and tell them they had to move out.
It's so interesting. It amazes me the misinformation sometimes that's floating around. And it's, the interesting part here is in the state of Florida, we're not an attorney state. So they're relying on realtors to get this right.
Absolutely.
Like to use these pre-printed forms either by Florida Association of Realtors or the one that's prepared by the Florida Bar and the Florida Association of Realtors, which is the one I prefer.
As do I.
And then, essentially at that point, you should know that, and you should be very well educated. And if you're not sure, you should be asking either your broker or an attorney to clarify that.
Yeah, and realtors can call me. That's why Hillsborough Title pays me. I'm here to help you guys through the forest and quagmires that can be Florida real estate.
And there's so many crazy things. So you've done real estate law for how long now?
Well, I did it in Gainesville for 5 years and then about 10 years here. So about 15 years total. I've always had some aspect of real estate to what I've been doing. But
you've seen a lot of stuff, though, in that time, I'm sure, as have I.
It's been interesting. It's been very interesting. Closings that melt down in the middle of closing. It's not unusual. Oftentimes, I do suggest that the buyer and seller come in at separate times.
Yes.
And really, if you're a seller, I think you picked up on this earlier. The seller, their closing is 10 minutes. They're going to sign, a couple affidavits, the deed, and the closing statement. For the buyer, if they're getting a loan, you got an hour at least worth of documentation for that loan. Like anything, like the FAR bar contract. When I first started practicing law, it was a 2-page contract.
Every time somebody gets sued, they add another page or clause, right?
Yes, that's exactly what it is. And they just keep going through and refining the contract, adding terms. The new municipal lien search that started last year as part of a revision, which has certainly been helpful. It searches
That's been a big one.
Yeah, open permits, which is huge, code enforcement violations, which may be unrecorded, and utility bills. There's nothing like a new homeowner calling the water department to turn their water on and finding out they got an $800 water bill that they got to pay first.
And that stuff attaches to the property, right?
Well, in that case, it doesn't actually attach to the property, but the water company just says, we're not going to turn your water on. It's really hard to live without water.
And could that be a title claim at that point? Is that why they're doing it?
It really is not covered by title insurance.
Okay.
It's an exclusion from coverage.
Gotcha.
But, similarly with open permits. We never searched open permits before. And open permits are never a problem until the new homeowner has to pull a permit to... We live in Florida. Every 10 years, we need a new air conditioner and a new roof. It's just the way it is. And that new homeowner goes to pull the AC permit, and guess what? They can't get one because the old roof permit wasn't closed. So they've got to go back, reopen that permit, have it inspected, hope it passes inspection. Sometimes they can be pretty costly to close.
I wonder why we had so much of that, like for so long. Like if it was just laziness on the county or city or municipality part, or if it was contractors not doing their part of the end.
It's funny. I know we're getting a little off topic. I apologize, but I had a new roof put on my house a couple months ago. I called. When I was a builder, there was actually a card, a sheet of paper out in front of the house. When the inspector came by, he signed it. And that's how you knew you passed inspection. You got the signed card. But I figured, that was in the 80s. Now everything's electronic. So I called the roofing company, a very good roofing company, very well respected, and said, hey, did my permit close? Oh, yes, it closed, no problem. So just to make sure, I called Gail and our Plant City office who does these searches. Said, hey, Gail, would you mind taking a look at, make sure my permit,
search.
It wasn't closed. It was open. I called the roofing company and they said, well, and I have no reason to doubt them. They said, we called it in, but somewhere between their call in, either it didn't get forwarded to the inspector could have dropped the ball. I have no idea.
So somebody between either the contractor didn't actually make the call, the inspector didn't actually go out there, or somebody it was a clerical error on the back end where they didn't plug it in.
One way or the other. So they were very apologetic. They're very nice about it. They just called and got the permit closed out. And it closed fine, but sometimes you never know. When we first started doing municipal lien searches, I said, hey, cool, I'm going to have my house searched. I had a final inspection on my pool, but they hadn't closed the plumbing inspection. Hadn't been finalized, so I had to call them and get them to come out, and they closed the plumbing permit.
Because we never did that over the last, several years. Not until the last couple of years have we done that. It came
in with the 2000, it's called the 2013 changes to the FAR bar. It started in September of 2013. And it's very frustrating for sellers who have no idea they have an open permit. It may have been 2 sellers ago who pulled that permit, but because we never did the searches before, and maybe they didn't have to have a permit in between, lo and behold, there's a problem.
What happens in the case where that contractor is just out of business? I mean, a lot of people collapsed and they just couldn't make it through the housing meltdown, so they closed their doors.
Certainly more common than not.
What are they doing with those? I mean, I know you guys can do an exception to title, but how does the homeowner actually deal with that?
Well, again, it's really an exclusion from title, but there is a method. You're probably going to have to get, number one, you're going to have to pay a fee to reopen the permit. Number two, you're going to have to probably get an engineer involved. And if you have this happen, you can call Hillsborough Title. We have an excellent engineer out of Brandon who is very reasonable. And you may have to get a contractor involved as well. The engineer we refer people to happens to have a son who's a general contractor, so they're a great team. They treat because we do refer a significant number of folks to them. They treat our folks very reasonably. And Aaron Davis, the owner of Hillsborough Title, as entrepreneurial as he is contemplating opening a company that will close open permits.
It makes sense. I mean, this is like this white elephant in the room that a lot of people just didn't even. I know when I first saw the change, I'm like, municipal lien search? Like, what the heck is that? What are we supposed to do with that? Where did this come from?
Well, it's my understanding that the committee.
Didn't that come from South Florida?
The municipal lien search?
Yeah. Wasn't that like something that started in South Florida? Yeah.
Probably. A lot of stuff like that happens in South Florida. But.
And so
sorry.
South Florida on up. And
on up. And, when you think about it, the committee actually considered doing away with the requirement of a municipal lien search because it was so frustrating to so many people. But if you think about it, it's really protecting the buyer. And, these days we're all about consumer protection.
Right.
And it's not fair to that buyer to buy a house, have to put in a new air conditioner to find out that the permit was never closed. Especially after 2004 and the hurricanes in 2004 down in the Fort Myers area. Right. So many folks had to have roofs immediately. People
get sloppy with work. When they're busy, they get sloppy.
Exactly. They just get sloppy.
It's we could probably take this whole conversation into another whole direction, even with additions that aren't permitted and all kinds of stuff, but we'll have to save that conversation for another day. Jim Holloway, thank you so much for joining me in studio today to talk about Post and Pre Occupancy. I appreciate your time. I value it.
Thank you for having me. It's been a pleasure.
You've helped us and our clients tremendously, and we love having Hillsborough Title as our show partner. So
we love being a show partner. And certainly appreciate your business as well.
Absolutely. You're listening to Tampa Home Talk. I'm your host, Katrina Madewell. So happy to bring you these details today. We hope that this has helped you in one way or another, at least CYA a little bit if you're in the middle of a real estate contract with us or otherwise. As always, if we can help you out, you can check us out on the web. We're at tampahometalk.com. You can also find us on Facebook and Twitter. Just look for Tampa Home Talk. Phone numbers and everything are on there. We'll post the information for Jim Holloway, our guest. And we're here to help you anytime we can. But for this week, we're out.
You're buying a house. Congratulations. So while you're worrying about the paperwork, leave the moving part to us. We're Woody & Sons Moving Company, a Florida licensed and insured mover, and we offer same-day written estimates. Plus, no sneaky mileage, stairs, or additional stop fees. All we ask is that you check out our great ratings on Google and Angie's List Then go to woodyandsons.com to learn more. Whether you need a full-service pack and move or some extra hands, at Woody & Sons Moving Company, we move you.
You've heard this before. Interest rates are at all-time record lows. But if your interest rate is 4% or above, you owe it to yourself to call Silverton Mortgage Specialist. Silverton is a direct lender, and the best part about this is that the entire loan process is handled in-house. From application to close, we do it all in the same building, which means that our loans close fast and our clients know what's going on every step of the way. Our contact info is located on TampaHometalk.com under Radio Show. What makes Silverton different? Products. We offer VA, FHA, USDA, and conventional loans pricing. Best rates with the lowest closing cost. Process everything in-house. It's handled right here and not outsourced to anyone that no one can reach. This way we can avoid surprises. Our people are simply the best, and we know you'll agree. What will closing Silverton Mortgage Specialist mean to you? A smooth process, real home loan value, and personal attention from real professionals. Silverton Mortgage Specialists are here to serve you. Visit TampaHometalk.com under Radio Show for all of our contact details. NMLS 109600 is an equal housing lender and Florida and Georgia residential mortgage licensee.
Hi, this is Aaron Davis, owner of Hillsborough Title. Hillsborough Title is a local, family-owned title agency here in Tampa Bay. Our service, strength, and knowledge make us different. We've served Tampa Bay area for over 30 years. From Polk County to the Gulf, Pasco to Manatee, Tampa Bay, we've got you covered. Call us at 813-712-8888 or visit us on the web at thebesttitle.com. That's thebesttitle.com.
Imus in the morning.
We continue here on the Imus in the morning program, dealing with a developing situation this morning. The I-Man has gone to the bathroom, and he will be making his return, we think, here in just a moment. Let's go live to our bathroom cab.
No. What did you say when I was away?
You're in the bathroom. That's all.
What we're doing to provide people with all these details?
I think people are interested. You know, people that are longtime listeners might be worried. They hear my voice when we come back from break. You never know what might have happened.
I think maybe I died, right?
Exactly, right. Yeah. So just try to reassure the audience.
What's so funny, Lou?
Imagine somebody opening that bathroom door and finding you just dead in there. Oh, my God.
All Elvised out. You bastards. One of these days, I will die. Then what are you going to do?
That would be tragic.
Son of a... Look for a job. Look for a job? Is that what you said?
What else? File for unemployment.
Catch Imus in the morning, right here weird, on the stations of the Tan Talk Network.
No paper in here at all. What is too much espresso?
They were the movies that shaped a generation.
Bueller.
He's sick.
They made us want to be fighter pilots.
I feel the need for speed.
They made us admire the class bad boy.
Eat my shorts.
They taught us that running a car in reverse does not take miles off the odometer. Tampa Theater is putting them back on the big screen again. The totally 80s classic movie series is 8 weeks of rad retro favorites like Footloose, Blade Runner, and Better Off Dead. Every Sunday at 3 at Tampa's historic movie palace. So dig out those Ray-Bans and leg warmers and visit tampatheater.org for show dates and tickets. Seriously, it's going to be awesome.
I am serious. And don't call me Shirley.
Hi, this is John Austin, host of the book club on the Tan Talk Radio Network. I spent 35 years in publishing, and today I want to tell you about a book that can change people's lives. The book is No Cash, No Problem, and the author is Dave Wagenford with Ali Pervez. Dave Wagenford is one of the greatest barter experts in the world, and he's bartered over $500 million worth of goods and services. You want to remodel your house, but the cost is just too high, or maybe there's an automobile that you've dreamed of owning but thought you never could afford. This book will tell you how you can do both of those things, plus hundreds more with little or no cash and without going into hock for the rest of your life. Maybe you're a business owner with a cash flow problem that leads to low or non-existent profits. Read this book and see how you can increase your cash flow and your profits by time-proven techniques. The book again is No Cash, No Problem, and you can buy it now on Amazon for just $7.98 for the ebook edition. Do yourself a big favor and buy it today.
Tampa Bay's fresh new talk radio. Tan Talk.